Singapore Ministry of Health and Ministry of Law, Senior Parliamentary Secretary, Madam Rahayu Mazam, officers and members of the Singapore International Arbitration Center, SIAC, led by their Registrar, Mr. Kevin Nash, Undersecretary for Planning and Project Development of the Department of Transportation, Timothy John Batan, Office for Alternative Dispute Resolution, Executive Director, Undersecretary Irene D. Torres Alogok, Government Corporate Counsel Solomon Hermosura, leading arbitration practitioners from the Philippines and other parts of the world, other distinguished guests, ladies and gentlemen, good morning. As you may all know, the judiciary has the constitutionally vested power to settle disputes between parties who come before it. But this in no way means that it is only the judiciary which has the knowledge and authority to properly bring justice to those who seek it. In today's ever-changing society, commercial transactions are becoming more globalized due to the emergence of open economies and the growing interdependence between countries and private entities alike. The subjects of contracts are becoming more complex, not only because their parties hail from the different parts of the world, but because the swift development of technology precedes and outpaces government regulations and response. Necessarily, the disputes which these transactions give rise to may be intricate and unprecedented. And while the judiciary never shies away from taking cognizance of complicated questions of fact and law, I cannot overemphasize the essential role that SIAC and other alternative dispute resolution institutions play in the timely and orderly administration of justice. As the court expressly acknowledged in the case of Lanusa versus BF Corporation, our jurisdiction adopts a policy in favor of arbitration, as it allows the parties to avoid litigation and settle their disputes amicably, more expeditiously by themselves and through their choice of arbitrators. This being the case, arbitration, along with other alternative methods of settling disputes, is being encouraged by the Supreme Court. In the 2003 case of LM Power Engineering Corporation versus Capital Industrial Construction Groups Incorporated, this court prefaced its discussion by highlighting the importance of alternative dispute mechanisms. By enabling the parties to resolve their disputes amicably, they provide solutions that are less time-consuming, less tedious, less confrontational, and more productive of goodwill and lasting relationships. In the same case, the court recognized that arbitration is regarded as the wave of the future in international civil and commercial disputes. Indeed, the future being contemplated more than 2 decades ago has already arrived. In recognition of this reality, the Supreme Court has taken concrete steps in ensuring that arbitration is advanced not merely as a back-of-mind option, but as a primary mode of seeking justice insofar as it is practicable. In 2009, the Supreme Court issued AM number 0711-08-SE, otherwise known as the Special Rules of Court on Alternative Dispute Resolution or the Special ADI Rules. Under its Statement of General Policies, the Court expressly declared its resolve to actively promote the use of various modes of ADR and to respect party autonomy or the freedom of the parties to make their own arrangement in the resolution of disputes with the greatest cooperation of and least intervention from the courts. To this, the objectives of the special ADR rules are to encourage and promote the use of ADR, particularly arbitration and mediation, as an important means to achieve speedy and efficient resolutions of disputes, impartial justice, curb a litigious culture, and to neglect court dockets. So as not to prostrate this espoused policy, the Court, through the special ADI rules, meticulously outlined the Court's precursory role in repairing parties to arbitration in very exceptional cases providing judicial relief. The Supreme Court has also made this policy crystal clear through its decisions. In Prehope Electronics versus Technology Electronics Assembly, this Court, once again solidified the rule that the award of an arbitrator cannot be set aside for mere errors of judgment, either as to the law or as to the facts. Courts do not have the power to amend or overrule an award merely because of disagreement with matters of law or facts determined by the arbitrators. They will not review the findings of law and fact contained in an award and will not undertake to substitute their judgment for that of the arbitrators. This is because doing so otherwise would make an award the commencement and not the end of litigation. Subsequently, in Mabuhay Holdings versus Semcorp Logistics, this court declared that it adopts the narrow approach in determining whether the enforcement of an award is contrary to public policy. The legality or immorality of the award must reach a certain threshold, such that its enforcement would be against the state's fundamental tenets of justice and morality, or would blatantly be injurious to the public or to the interest of society. Moreover, as I have previously mentioned, the court is currently working on revisions of the rules of civil procedure. In line with this, one of the major suggestions being considered is making exhaustion of alternative modes of resolution, such as arbitration, a prerequisite for filing civil and maybe and other types of actions before the courts. As you may also be aware, we are going on our third year of implementation of the court's reform agenda, the Strategic Plan for Judicial Innovations 2022 to 2027, or the SPJI. Through the SPJI, the court aims to not only champion efficiency, innovation, and access within the courts, but also harness alternative options through which individuals and entities may obtain speedy and equal justice. Arbitration has an immense potential of exponentially increasing efficiency and access to justice as contemplated under the SPJI. Through strong partnerships with experts and practitioners inside and outside the country, we can build our country's capacities and raise awareness of the opportunities which arbitration brings. Although the SPJI is being spearheaded by the court, it bears stressing that its success can only be obtained with unwavering support and cooperation of all stakeholders. In closing, let me express my sincerest gratitude to the Singapore International Arbitration Center for championing international arbitration not only in the Philippines but all around the world. With SIAC as one of the most respected arbitral institutions, I have no doubt that today's participants will gain invaluable insights and knowledge on the true potential which arbitration offers. May you continue to support us in our efforts to render fair, transparent, and timely justice to all. Thank you very much. I wish you a fruitful and successful conference.